morning, the US Supreme Court has ruled that Donald Trump has some immunity from prosecution for official actions taken while he was in the White House. The landmark decision is likely to delay his trial for interfering in the 2020 election. The former president described the decision as a big win. Our North America editor Sarah Smith reports.
The powerful Supreme Court has the final say on what presidents can and cannot do. Today's historic ruling means a president can never be prosecuted for anything that's part of their official duties, but they do not have immunity for non-official acts. So what does this mean for the criminal cases against Donald Trump?
Fight for Trump! Fight for Trump!
When he spoke to supporters on January the 6th, was he officially acting as the president or as the losing candidate?
We fight like hell, and if you don't fight like hell, you're not going to have a country anymore.
Donald Trump is facing criminal charges related to the January the 6th riot and attempting to overturn the election results.
Hey guys, Adam is here. So what just happening, guys? The Supreme Court's Trump versus United States ruling functioned like a bomb with two detonation codes. The first built an enormous shield, sweeping presidential immunity for official acts strong enough to effectively dissolve the federal election interference case by sending it back to lower courts to sort through what was official, buying enough time for the election to flip and a sitting president to walk free from indictment. The right celebrated. The legal team called it a structural triumph, and in that narrow sense, it was.
President Trump's attorneys are pushing the Supreme Court to endorse a huge expansion of presidential power. An ABC News review finds nearly a third of Trump's unprecedented 29 appeals to the high court in a second term have invoked the monumental 2024 immunity case. Legal analysts also say they see its influence in how the president is pushing for the prosecution of enemies and dropping charges against allies. On Monday, the Supreme Court justices cleared the way for contempt of Congress charges to be dropped against former Trump advisor Steve Bannon. Now legal experts say these appeals could shape how much power a president can exercise and how far the courts are willing to go. ABC News senior Washington reporter Devin Dwyer has the latest. So Devin, how big of a deal are these findings and what does this say about Trump's presidential power?
Over 2 years now, Perry, since that immunity decision, and we're seeing its long reach. Remember, in 2024, the Supreme Court gave Trump immunity from criminal prosecution. But one of the things it also did was it enshrined in the text of the opinion.
But the second detonation code blew inward, because the same ruling that grants a president near unlimited immunity for official acts also strips away any claim that those acts can be hidden from congressional scrutiny or shielded from impeachment. The fortress has no roof. The back door stays open. And right now, that back door is what's fueling the impeachment drives, war power standoffs, and constitutional reckoning tearing through Capitol Hill.
Now at the Supreme Court, the justices just made a historic ruling in the case of Donald Trump v. the United States, saying, quote, under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. The decision goes on to say there is no immunity for unofficial acts.
But that is not the part of the story that has the marble hallways of Congress vibrating with tension right now. That is not the part that has legal scholars burning the midnight oil over committee subpoenas and contempt resolutions. While the victory laps were being run on conservative airwaves, a critical component of the exact same ruling was being glossed over. A component that functions like a permanent, indelible warrant waiting to be served. Because in the very same breath that the court granted immunity for official acts, it drew a line in the sand using permanent ink.
Well, Jackie, this all relates to the case against Donald Trump here in Washington, D.C., that he allegedly conspired to subvert the results of the 2020 election, culminating, of course, in the attack on the Capitol on January the 6th. Now, he argued that he should have immunity from prosecution because all the actions he took, he claimed he did in his official capacity as president. Now, he did not get that blanket immunity from the Supreme Court today. Instead, the Supreme Court partly agreed with Donald Trump in their ruling that a president's official acts, as you said, should be immune from prosecution, but it said a president's unofficial or private acts should not be immune, and it's passed the whole case back to the lower court here in DC for them to decide which acts should be official and which were private in this particular case.
For unofficial acts, private machinations, personal financial schemes, hush money deals, or conduct undertaken purely as a private citizen rather than as a commander-in-chief, the immunity is exactly 0. The court did not whisper this part. It declared it explicitly. And that declaration did not vanish when the election interference indictment was dismissed. It did not evaporate when the Air Force One steps were climbed. It sits there, immutable, in the text of the ruling, serving as a roadmap for every state prosecutor, every congressional investigator, and every legal analyst trying to decipher exactly where the shield of power ends and the vulnerability of the private individual begins. Right now, amidst a backdrop of foreign policy flashpoints with Iran, a domestic economic whirlwind over tariff refunds, a vicious ideological civil war within the MAGA movement, and an administration locked in a multi-front war with the federal judiciary, the question of accountability is not a law school hypothetical. It is the live wire running underneath every debate on the Hill, fueling calls for the 25th Amendment and driving the most ferocious oversight battles Washington has witnessed in years. We are about to walk through every intricate layer of what the ruling actually decrees, what it tangibly means, and why. 2 years after the ink dried, it is still sending shockwaves through every branch of the government with the force of an earthquake. Let us first clear away the fog of cable news shorthand. Most coverage of this decision has either been flattened into a simplistic headline, "Trump gets away with everything," or reduced to a dry technical analysis that misses the political dynamite embedded in the footnotes. Neither approach captures the bizarre dual-nature reality that is currently defining the limits of executive power. The case originated from the federal indictment alleging a concerted effort to subvert the peaceful transfer of power. The defense put forward an argument of maximalist scope, that a president is untouchable, absolutely shielded from criminal liability for anything done while holding the title, lest the fear of future prosecution paralyze the decision-making required to run the country. The Supreme Court did not buy that extreme version of the argument wholesale. They did not hand over a blank check with infinite credit written on the memo line. Instead, they constructed a complicated 3-layered legal cake, and depending on which layer you are standing on, you are either invincible or completely exposed. The first layer is absolute immunity. This covers the core, exclusive prerogatives of the executive, issuing pardons, commanding the armed forces, executing federal law, and directing the internal operations of the executive branch. The second layer is presumptive immunity. This is a broader, murkier category for other official actions. The government can theoretically pierce this shield, but the burden of proof is mountainous. They must demonstrate that allowing the prosecution would impose no chilling effect whatsoever on the functioning of the executive branch. And then there is the third layer. The ground floor, zero immunity. This applies unequivocally to unofficial, private, and personal conduct. This is the arena where the individual stands naked before the law, stripped of the trappings of the office. 3 tiers of justice, and the tier that is currently causing political aneurysms in the Capitol basement is the one at the bottom. Let's dissect the architecture of that immunity fortress before we examine the open field surrounding it. Understanding the height of the walls makes the lack of a roof over the private residence that much more glaring. The court was remarkably specific about what the absolute immunity tier protects, and the examples are genuinely breathtaking in their scope. The communications with Justice Department leadership regarding the investigation of alleged voter fraud? Absolutely immune. The court reasoned that the president is the chief law enforcement officer. Directing the DOJ is a core constitutional function. This means that leaning on the Attorney General or the Deputy Attorney General to open inquiries, even if those inquiries are predicated on falsehoods, even if the motive is purely corrupt political gain, falls safely within the cordoned-off zone of unreviewable executive discretion. That is a seismic shift in the understanding of presidential norms. The dissenting voices on the bench did not hold back in their alarm. Justice Sotomayor painted a chilling hypothetical, suggesting that under this framework, a commander-in-chief who orders the elite units of the military to neutralize a political opponent could theoretically walk free, so long as the order was dressed up in the bureaucratic language of an official national security directive. Justice Jackson described the ruling as breaking new and dangerous terrain, creating a chasm in the rule of law that had never previously existed. Civil liberties advocates described the opinion as a loaded weapon left in plain sight, waiting for a future occupant of the office to pick it up and use it for ends far removed from the Constitution's design. These are not hyperbolic talking points from partisan operatives. These are sober, dire warnings from the highest legal authorities in the land, and they warrant serious contemplation because the category of core constitutional power is far broader than the average citizen might assume. Now we move to the middle tier, presumptive immunity. This is where the legal battles have been thickest and most frustrating for those seeking immediate accountability. This category covers acts that are official but not strictly part of the president's exclusive constitutional toolkit. The court said that for these acts, the presumption is immunity, but it is a presumption that can be rebutted. The problem, as lower court judges are discovering, is that the bar for rebuttal is set so high it nearly scrapes the ceiling of the absolute tier. The government must prove that allowing the case to go to a jury would not intrude upon the authority or functions of the executive branch. In the wake of the ruling, the district court was tasked with sifting through a mountain of evidence regarding pressure applied to the vice president to disrupt the certification of electoral votes. Was that an official act, or was it a campaign act? The pressure placed on state officials, like the infamous call to the Georgia Secretary of State seeking to find votes, is currently stuck in this legal purgatory. Some of those interactions involved private citizens operating outside the federal chain of command, which nudges them toward the unprotected third tier, but the sheer volume of litigation required to make that determination is a victory in itself for the defense. And of course, the entire process was short-circuited by the return to power, which triggered the long-standing policy memo shielding a sitting president from federal prosecution. The federal case evaporated not with a bang of exoneration, but with the quiet procedural whimper of a dismissal. And that brings us, finally, to the flashpoint. The tier that matters most in the current, scorching political environment. The unofficial acts category. This is the explicit, neon-lit boundary the court painted across the landscape of presidential conduct, private actions, personal dealings, non-governmental schemes, the payment of hush money, the manipulation of private business ledgers. Actions undertaken not as the President of the United States, but as a private individual running a business or managing a personal crisis. On this ground, the court was unanimous in clarity. There is no immunity. None. Not presumptive, not absolute, just zero. And the concrete consequence of this clarity is already baked into the judicial record. The New York conviction on 34 felony counts for falsifying business records in connection with a payment to an adult film actress rests squarely on this side of the line. The checks were signed from a personal account. The reimbursement scheme was routed through a personal attorney. The ledgers that were doctored belonged to a private entity, not the White House Office of Records Management. These actions have zero connection to the duties of the presidency. Therefore, the Supreme Court's shield does not extend an inch over that particular legal battlefield. The conviction stands, and the appeals process, while grinding forward on separate technical grounds, cannot avail itself of the immunity ruling to simply wipe the slate clean. Legal scholars are keenly aware that this same logic applies prospectively. Any future investigation or prosecution centered on business fraud, private financial chicanery, or personal agreements made outside the scope of official duties operates in a legal vacuum where the 2024 immunity ruling offers no protection whatsoever. This is what the commentary accurately identifies as the functional equivalent of a permanent alert. It is not an arrest order issued by the Marshal of the Supreme Court, but it is a permanently illuminated map showing every prosecutor in every jurisdiction exactly where the high walls of the fortress end and the open field of liability begins. But the reverberations of this ruling are not confined to criminal dockets in Lower Manhattan or Fulton County. The impact on the legislative branch has been just as profound, arguably more so, because it has forced a reluctant Congress to stare into the abyss of its own constitutional responsibilities. When the Supreme Court effectively walled off the vast majority of official presidential conduct from criminal prosecution, it sent an unmistakable message to Capitol Hill. The message was, "We are closing the courtroom door. If you want accountability for how the executive branch wields its official power, you must use the tools the Constitution gave exclusively to you." That means impeachment. That means robust oversight backed by the power of the purse. That means enforcing the War Powers Resolution. You cannot outsource the dirty work of checking a president to a special counsel anymore, not for the broad universe of actions that fall under the umbrella of official duties. That realization has hit the Democratic caucus with particular force. For years, the specter of a future indictment served as a kind of background radiation, a deterrent against the most extreme abuses of official power. That radiation has been scrubbed clean for the top tier of presidential conduct. The only tool left in the box for those actions is the heavy, unwieldy hammer of impeachment. This is precisely why the recent flurry of impeachment filings, with their laundry list of grievances spanning foreign entanglements with Iran, the domestic use of military assets, and sweeping immigration enforcement tactics, cannot be dismissed as mere political theater. It is a direct, structural response to the accountability vacuum the court created. If criminal prosecution is off the table for official acts, then a congressional refusal to even consider impeachment isn't a sign of legislative restraint. It is a de facto admission that for the entirety of the official sphere, there will be zero accountability, a blank check endorsed by silence. Every lawmaker who scoffs at the mention of impeachment articles is implicitly endorsing that vacuum. Here is where the narrative takes a turn that confounds the simplistic Trump court narrative. It is a story of a shield in one hand and a leash in the other. The very same conservative majority that handed down the immunity ruling has, with equal force and consistency, been systematically constraining the boundaries of executive power in the second term. The landmark decision, gutting the environmental tariffs as an unconstitutional usurpation of congressional authority from the very first day they were imposed, is Exhibit A. The decisions blocking the unilateral federalization of state National Guard units without proper consent, and the rulings applying the major questions doctrine to prevent sweeping agency restructuring without explicit congressional approval, are Exhibits B and C. This is the same bench. The same 6-3 ideological split. Some of the same jurists whose careers were shaped by appointments from the very president they are now reining in. They have simultaneously granted him immunity from legal consequences for what he does, while also telling him he is constitutionally prohibited from doing a great many of the things he wants to do. Legal analysts describe this dynamic as a shield and a leash. You are immune from prosecution for the actions you take, but we will stop you from taking the action in the first place. The combination raises a profound and currently unanswered question. If a president is immune from prosecution for an official act, but the court says that act is unconstitutional and must cease, what is the enforcement mechanism if he simply ignores the court's leash? If the criminal justice system cannot touch him, who ensures compliance? The answer, implied by the court's entire body of recent work, points inexorably back to Congress, back to the political system, back to impeachment. The courts will issue the injunctions. The Congress must supply the consequences for ignoring them. The unofficial acts dimension also collides with one of the most combustible and politically charged document fights in Washington, the ongoing battle over the Epstein files. The bipartisan subpoena effort in the House, the allegations swirling in the sealed records concerning private conduct with a minor, allegations that have been vehemently denied, all of this plays out under the glaring spotlight of the immunity ruling's carve-out. Whatever the ultimate truth of those documents reveals, the legal framework for assessing it runs directly through the unofficial acts corridor. Any behavior, any association, any relationship that occurred outside the strict time-stamped bounds of presidential duty is utterly untouched by the protections of Trump versus United States. The bright line the court drew is not just a line, it is a high-contrast border wall. And it means that the fight over those sealed files, much like the ongoing appeals in the hush money case, exists in a zone that the Supreme Court itself has designated as entirely open season for legal and political scrutiny. Let us condense this sprawling legal landscape into a clear set of observations about why this ruling continues to detonate inside the Beltway. First, the ruling is a paradox of architecture. It is both a ceiling of protection and a floor of vulnerability. The ceiling is real. It covers the command of the DOJ, the management of the military, and the core functions of the executive. That is a genuine and, to many, terrifying expansion of the concept of executive privilege. But the floor is just as solid. The hush money conviction sits on it. The private business dealings sit on it. The Epstein document controversy sits on it. The Supreme Court has not created a lawless state of nature. It has created a bifurcated reality where the man is sometimes a king and sometimes just a citizen. The map of where he is, which is now a matter of public record. The ruling has forcibly transferred the burden of accountability from the judiciary to the legislature. The Supreme Court has effectively said to the House of Representatives, "He's your problem now." If pressuring the Justice Department is an immune official act, then the remedy for a corrupt use of that power is not a prison cell. It is removal from office. The constitutional design always intended for Congress to be the ultimate check on the executive, but for decades, the threat of post-presidency prosecution served as a secondary, quieter deterrent. That secondary deterrent is gone for official acts. This puts immense pressure on a Congress that is institutionally averse to using its most extreme powers. Every time an impeachment resolution is tabled, every time a subpoena deadline is ignored without consequence, the gap between the accountability the Constitution demands and the accountability this political moment provides grows wider. That gap is the source of the fire on Capitol Hill. It is not just a partisan squabble, it is a structural failure of the separation of powers. The dissenting opinions in Trump versus United States are aging with the potency of a fine wine left in a cellar, only this wine is laced with gunpowder. Justice Sotomayor's vivid hypothetical about assassinating a rival using official means was dismissed by some as alarmist rhetoric at the time. But in the context of ongoing debates about the limits of military power, the deployment of forces domestically, and the rhetoric surrounding internal enemies, that hypothetical no longer feels like a law review thought experiment. It feels like a warning label that was ignored. The dissents have become the foundational text for the accountability movement in Congress. They provide the legal and moral justification for every 25th Amendment letter, every impeachment article, and every war powers challenge. The majority opinion wrote the new rules. The dissenters wrote the user manual for how to survive them. Finally, we must address the political reality of this moment. The administration is operating with the confidence of an entity that believes, with good reason, that the personal cost of exceeding constitutional bounds has been drastically reduced. The court has said, "We won't let you do X," the leash. But it has also said, "And if you try to do X anyway, you won't go to jail for trying," the shield. This creates a perverse incentive structure. It encourages brinksmanship. It encourages the testing of judicial patience. And when a federal judge finds the administration in contempt, as has happened in the immigration enforcement context, the question immediately becomes, so what? The so what used to be the threat of a future perjury trap or obstruction charge. Now, under the immunity framework, the so what for an official act of contempt is impeachment. And we are back to a Congress that is largely unwilling to act. The Supreme Court built a system where the primary engine of presidential accountability is political will, not legal jeopardy. It shifted the weight of the Constitution from the courthouse steps to the campaign trail and the House floor. That system only functions if the people watching from the galleries and voting in the booths understand the stakes. The arrest alert is not a literal warrant from John Roberts. It is a stark, legal demarcation of the battlefield. It is the sound of the Supreme Court saying, "We have done our part. We have drawn the lines." If you want the private citizen to face justice, the courts are open. But if you want the official actions of the presidency checked, you better look to your elected representatives. Right now, the silence from that branch is deafening, and that silence is the fuel feeding the fire that is consuming Capitol Hill. We will remain on this beat, tracking every twist in the appellate courts, every filing in the House, and every confrontation between the branches, because the story of this ruling is not a piece of history. It is the defining drama of our present political existence. Subscribe, hit the bell, and join us as we watch this constitutional high-wire act unfold, because understanding where the shield ends is the only way to know where the law still breathes.